then the courts have to get into the procedure of how to evaluate creativity. Judges may be very good at judging, but evaluating creativity, well, maybe they have to rely on a lot of experts. There are some cases, however, that give us some guidelines. For example, in some cases there is something that holds that if it's a fictional work, presumably more creativity goes into the work than non-fictional work. So I have some difficulty with that. There's a lot of non-fiction work that requires a lot of creativity, but for some courts, they say if it's fictional work, that factor tends to favor the plaintiff. If it's non-fictional work, it favors the defendant. In several cases, there is something to the effect that if the defendant copies an unpublished work, then that factor tends to favor the plaintiff. If it's published, it tends to favor the defendant. The rationale behind that is that copying something that's unpublished detracts from the initial impact of first publication. The third is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. If a lot of it is copied, then that factor favors the plaintiff. If a small amount, like a snippet, a few pages, that factor tends to favor the defendant. I once had a case in which the copyrighted work was a 56-minute videotape. The defendant copied one freeze frame and published it in a tabloid magazine. The plaintiff, the copyright owner, contended that this was the most important part of the tape. The defendant said, well, it's only one freeze frame in a 56-minute videotape. The fourth factor, as we'll see, seems to be the one that the courts rely on the most. That is the effect of the use upon the potential market for or value of the copyrighted work. That is, the courts address the issue of what is the effect on the revenue stream or potential revenue stream of the copyright owner. And if the conduct of the defendant eats into the revenue stream, then that factor tends to favor the copyright owner. If the conduct is just inconsequential, doesn't lead into the revenue stream, that factor tends to favor the defendant. There are two cases that I've used to hopefully demonstrate the fair use defense. In one case, Princeton University Press versus Michigan Documents, the fair use defense was rejected. In the other one, Kelly versus Ariba Software, the fair use defense was sustained. There's a very substantial body of case law, as you can see from some of the litigation that's ongoing. The case law is going to expand substantially. But in the time that we have, I thought that perhaps these two cases might possibly place the fair use defense in context. In Princeton University Press versus Michigan Document Services, the case involved course packs. It's rather interesting that, well, this case was one in which the defendant, Michigan Document Services, run by Mr. Smith, was a course pack producer. He had a copy shop near the University of Michigan. And the professors would provide the students with a list of all the required readings. It could be something like 5 to 10 books, not the whole book, maybe 25 to 50 pages. It's kind of expensive to buy all of the books. So the professor would make the list of books available to the copy shop, the course pack producer. The course pack producer would get the books, make copies of them, put them into one course pack, and sell it to the students for profit. Well, Mr. Smith was one of the numerous course pack producers, and he contended that this was being used by students at the University of Michigan, a nonprofit educational institution, and therefore it was for educational purposes, and the fair use defense absolved him from copyright infringement. The case was filed in federal district court, as all copyright cases are. At the trial court level, the plaintiffs made a motion for summary judgment. It's a procedure in which the moving party says there's no genuine issue of fact. Everyone believes, everyone agrees that these are the facts, but based on these facts, I'm entitled to a judgment. Well, the trial court agreed, and both sides actually agreed on the facts. There wasn't much dispute in the facts. Both sides agreed to the facts, and based on those facts, the trial court granted summary judgment for the plaintiffs, Princeton University Press. There were two other plaintiffs. There was Macmillan and St. Martin. The case went up to the 6th Federal Circuit Court of Appeals, has appellate jurisdiction over Michigan and a number of other surrounding states. And the Court of Appeals, interesting, they had an expanded panel review this case. Most Court of Appeals decisions are decided by a 3-judge panel. In this case, they had 13 judges. They always have an odd number so that there's never a tie, although it could be under certain circumstances, but they try their best to avoid a tie. The case was decided 8-5 in favor of the plaintiffs. It'd be interesting to review all of the arguments on both the majority and minority side. We don't have enough time, but let's just look at the opinion, the rationale of the majority that ruled in favor of the plaintiffs. The judge who wrote for the plaintiffs actually wrote a personal anecdote into the opinion, something I seldom see. He said, thanks to relatively recent advances in technology, the course pack, an artifact largely unknown to college students when the author of this opinion was an undergraduate, has become almost as ubiquitous at American college universities as the conventional textbook. Well, I agree with him. There wasn't course packs when I was an undergraduate. You just got the book, and if you couldn't get it, you went to the library or borrowed it, or we just circulated amongst each other. Well, anyway, though, the course pack was produced by Mr. Smith. Both sides agreed on that. Another interesting dynamic in this case, which is rather significant, is that each of the plaintiffs, the publishers, Princeton University Press, St. Martin, and Macmillan, had a program of permission fees. Other course pack producers paid permission fees to the publishers to use their scholarly works. In fact, when the case was first filed in 1994, according to the trial testimony, the 3 publisher plaintiffs were collecting permission fees in excess of $500,000. The case came up to the Court of Appeals in 1996. I assume that the amount has gone up, and I assume today it's much higher. So there was this allegation by the plaintiffs that Mr. Smith was eating into the revenue stream and potential revenue stream when others were paying permission fees.